So let me now call our next case, which I think is going to be Camper against Camper, number 1612 of the 2019 term. When we have everyone on here, I'll ask Mr. Moran to step up.
Good morning, Your Honor. I'm Mike Moran. I can hear and see everybody. Can everybody see and hear me?
We're
Yes.
good.
Yes.
Whenever you're ready.
Okay, we can start. Good morning.
Mr. Moran, excuse me, just at the outset, I recall a footnote in your brief at some point, I think it was your brief, that issues of custody visitation, child support are not at issue. Is that correct? But yet I find in your brief a reproduction of the court's order with regard to custody and visitation. And I just want to be certain that custody and visitation either is or is not an issue.
We have not raised issues on that, Your Honor. I think the reason it's there is because I'm obsessive compulsive. I went back and looked at it and thought, well, maybe somebody would be more interested in that than I am. 2 orders did come down, and I thought somebody might, for whatever reason, be interested
Right.
as background. But no,
You've
we're not.
answered my question and I thank you.
Okay, thank you, Your Honor. All right, so good morning again, Your Honor. I'd like to talk briefly on behalf of Mr. Camper about the issues he's raised on appeal. So for a few minutes, let's talk about businesses and the 2 issues that we have in connection with the business or fractional interest in the business, which he owns, is whether they were marital or non-marital property and whether the court valued them properly. Mrs. Camper took the position they were marital property because they were acquired during the marriage in 2007. The parties were married in 2003. Mr. Camper came back and said, no, they were gifts to me. That was his testimony number 1, which seems like, if believed, which was up to the court, of course, that should have put the ball back in Mrs. Camper's court to refute that somehow. Number 2, he came up with a gift tax return, which I believe is reproduced on page 79 of the record extract, indicating that the fractional shares in the 2 businesses were gifts and the percentage wise of the gifts. So one would think that between his testimony and those gift tax returns, that would be sufficient to put the ball back into Mrs. Camper's court. But number 3, on examination, and I think it was by her own counsel, she said that they were given to him. So it seems to me that there is ample testimony in the record and evidence in the record to show that Mr. Camper has in fact met his quote unquote burden or his obligation to trace, if you will, the assets to a non. And it seems to me that puts the ball back in Mrs. Camper's court to.
We're losing your volume.
I'm sorry, is that any better? It's a little hard to.
No.
Try again. We can see you, but we cannot hear you.
All right, Mr. Moran, can you do a test? Can you speak real quick for me?
Hearing me, I've unmuted from my end. Okay.
Good.
All right. I will. Yeah. Technology. You can't live with it. You can't live without it.
Right.
We understand. Go right ahead.
Okay. So at any event, it would seem to me that those 3 pieces of evidence would be enough to put the ball back in the Mrs. Camper's court to go forward and attempt to carry her ultimate burden of persuasion as to whether or not these were marital assets. Number 2, even if you think that they are marital assets, there comes the question of valuation. And quite simply on that point, I think where you're measuring or trying to come to a valuation on something as exotic as a small business and a fractional share in a small business, I think you just need an expert, you need an appraisal, and that wasn't done here. So she has no competency to offer a valuation as to what the business would be, let alone the fractional shares in the business, which could be something entirely different. I don't know what these businesses would trade on the open market. Number one, and a fractional share may have some, some value on or decrease in the value because it's only fractional, not all. In any event, as I see the case, it was up to her to establish the value of those assets if they were marital assets, and you really don't have any competent evidence to do that.
Can I go back to the gift issue for 1 minute?
Yes.
One thing that I didn't see explained, and I could have just missed it, is there's a document in the record extract, the share journal. It looks like a stock ledger, maybe,
Yeah,
for the North Coast Company, and there's some kind of entry on 12/31/06 that the document's not self-explanatory, but maybe it means that stock certificate number 3 for 250 shares was issued to Rudolph G. Camper. Is that your client on 12/31/06?
my understanding it is Rudolph G. Camper.
So what's the meaning of, how do we square this whatever the share journal means with the other evidence of the gift tax returns that seem to indicate that he received fewer than 250 shares by gift. Or maybe it was 250. I don't know.
So if just to orient us, I think Your Honor's looking at page E78 of the record extract, and then
I'm looking at E74, the share journal. There's a share journal for North Coast. There's also, and
it looks like we
seems to say that on 12/31/06 he got 250 shares. Is that the same transaction as the one? Did that transaction occur? And if it did, is that the same transaction as the one that's reflected in the gift tax return?
Your Honor, I have no information on that. What I was thinking about is that if you go to E77, or he could go to E77, there is a stock certificate to Rudolph G. Camper for 250 shares and no par value.
Yeah.
Right.
Now, what I'm thinking is if you flip over to the gift tax return on E84, is the statement that shows the 25 shares.
Right.
What I glean from that is that evidently the shares that are referenced there do have some value, and I'm not an accountant, and I don't do this for a living by any means, but I'm looking at this and I'm seeing adjusted basis of the gift value at date of gift. So I am inferring from that it's a different transaction because the shares reflected in item number 2 and 3 on the federal statement apparently have some value, and the stock certificate, which looks like it would relate to the journal, is no par value. So, and I don't recall anything in the testimony that attempted to relate those, but that's what I gleaned from that. That's the best I can do.
Okay.
Okay.
You're about to go through your initial 7 minutes. You're free to continue, but you'll be cutting into the 13 minutes that you've reserved for rebuttal.
Right. So let me just cut into that for a minute or two. And The argument on valuation is basically concluded. We don't think that there was competency on the other side, and it was up to them to prove value, and that was not done. We think somewhat the same problem occurred with the clocks and the instruments. Now, might be a little tighter question here because you have a clock in your house and you might have a musical instrument, but I don't know that these would be considered antiques. Evidently, somebody thinks they do. So you may be getting into the realm here, and we make the point in our brief that as far as that's concerned, you probably should have expert testimony on the value of that as well. I know that parties debated that back and forth, but there didn't appear to be any appraisal on those items.
Well, who's got the burden of proving? And doesn't the law require it seems like the law requires the judge to make an evaluation of these items of personal property. How can the judge do what the judge is supposed to do if the parties don't come up with expert testimony when it's required?
Then I think what you have to do is fall back on the burden of proof and say, well, who's got the burden of proof in this? My understanding is that the plaintiff, being the moving party, has the burden of proving the nature of the asset, the identity, and also has the burden of proving valuation.
And what's your basis for that? I mean, I understand the argument that typically a plaintiff bears the burden of proof, but why here?
Yeah. Your Honor, I'd leap through my brief, but I think we cite that in Interbichler.
Oh, that's Judge Hollander's opinion for.
I believe so. Yeah. Yeah. I believe there's 2 or 3 opinions I think that we cite in our brief that indicate where the burden of proof was. I was trying to be very careful on that, but that's why I think after the plaintiff offered his testimony, or I'm sorry, the defendant offered his testimony on the houses, the ball went back into the plaintiff's court.
But at bottom, the only numbers the court had before it were from the
Parties themselves.
pre-trial statements.
That's how I see it, Your Honor. The joint statement, the 9207. Yeah. I think, yeah, but I don't, here's what I think about that. I think the joint statements were not intended as a substitute for, well, number one, the committee note says the joint statements are not intended as a substitute for discovery.
I understand that, but if that's all that's before the court, what's the court to do?
Well, but
without expert testimony or appraisals.
Without expert testimony or appraisals, I think that 9207 still doesn't give the court the right to fashion for its own self what it should do. I think the ball goes back and the court has to say to whoever carries the burden of proof in that, look, this was your obligation to come forward and produce sufficient evidence. If it's not there, it ain't there, and you don't succeed on that. I think you have to apply the rules of evidence, the rules of production of evidence. Otherwise, what you do is you put the court in the position of, number one, an expert, which the court isn't. And number two, it might be one thing for the court to come up with a methodology, but I think there's a stark difference between coming up with a methodology and the numbers. The court is not competent or capable of coming up with the numbers. I mean, if you have conflicting assertions of value on the 9207, what's the court supposed to do? Flip a coin? I don't think that's what our justice system requires. I think it's up to
that's the question I'm posing to you.
Why have the burden put on one side or the other?
Isn't the court allowed to find that it's at least the value that your client puts on it?
But they didn't do that, number one, and I don't know of any law that says that they're entitled to, or that they're obligated to find that, or they're entitled to find that.
Well, can't the court treat what your client puts down as the valuation as an admission by him as to what the value, what the minimal value is?
You know, most respectfully, it sounds good in theory, Your Honor, but in practice, where you have conflicting assertions and the parties are in conflict, I think it is better for the administration of justice for the court to say, look, it's your burden, you either satisfy it or you don't, because then, why what guidance does the court have to select one value or the other? Why is husband's value in something any better or for the court to accept than the wife's value? And I don't know of any standard.
The court has some sense of the court has some sense of the veracity of the people in front of it, and can't the court use its estimate of credibility to evaluate the credibility of the numbers that are being given to it by the parties?
Not when the numbers being given to by the parties require expert testimony where both parties don't have the competency to testify to it. So then you go back to my argument is, okay, who's got the burden of proof here?
It sounds to me like first of all, your client knows a lot about clocks and maybe watches, and both of them know a little bit about musical instruments because she's a professional musician, and I think he used to be one. So isn't that a factor that the court can take into consideration?
The court can take a factor into consideration, but playing a musical instrument isn't the same thing as knowing how much they're worth. Look, I play guitar. I bought my Martin 6-string in 1969 for $300, but I have no idea what it's worth today.
It's not hard to find out what it's worth. We'll talk some other time. I'll tell you what sites you can look at.
Well,
It's not hard.
I mean, you can go to the music house, but then do you need to go to somebody who actually knows what they're doing?
eBay, just eBay and Reverb. There are a bunch of sites where these things are sold, and you can get an idea what the market value is.
Okay, but I don't think there was really any. I'm not sure there's really any testimony of that as far as the clocks, the instruments. Although I understand the court's concern. You own it. I'm just saying a clock of these kind of clocks or these instruments we're talking about here may not be the kind of things that, even though they're personal property, that people necessarily have laying around their houses. Although I don't know, Steinways, they may be able to roll these things off of an assembly line. Now, I have no idea. But the point is, without a basis for valuation, I just don't think it's fair for the court to pick one in like that because it gets too much in the area of speculation.
I think it could be a reasonable deduction on the court's part that professional musicians know the value of their instruments, particularly musicians who are professional at the BSO level as she is. I suspect that. And I think the court would not be remiss in concluding that a professional musician would be able to assess the value of instruments.
If I may, Your Honor, I would offer back to you, I think that depends. She might be competent to, that might be a reasonable deduction in the context of, does she play a piccolo? But whether it's a Steinway, that might be something entirely different. If she doesn't play a Steinway and isn't conversant in it, then maybe that's not a reasonable deduction. Judge Arthur, I am going on to 444 here. I kind of like to cut off unless the court has.
It's fine. We'll reserve the balance of your time.
Okay. Thank you, gentlemen.
Thank you. Mr. Ruben. You need to, there you go.
Thank you. I did. Can you hear me?
Yes, sir.
Thank you.
Okay, very good. Thank you. May it please the court. I do think I want to clarify what Judge Sheriff said. Yes, we're not talking about custody and visitation and child support, but it is important to know that the entire case was tried at the same time. And while initially, the judge, after the trial, I was the trial lawyer in that case for her, and gave her opinion as to custody, visitation, child support, because it was sort of important because they were starting school. And then she reserved time and gave herself 90 days to do the judgment. But the credibility issues that were raised in the custody portion, I think also perhaps affect the credibility issues on all the issues in terms of valuation and things like that. In other words, Mr. Camper asked for something in the custody case that he did not get. He asked for joint legal custody, he didn't get it. He asked for more time with the child, he didn't get it. So it all bleeds over in terms of his credibility. And that's where I start with the property issues, which is the standard language, which the court's well aware of, which we put in our brief, that the court has wide discretion in a family law case with regard to a monetary award in terms of judging the credibility of the parties. And when the evidence is conflicting, that it is charged to the trial court to determine the values, to determine whether it's, the three-step process. One, whether or not it's marital property. Two, what the value of the property is. And three, whether or not there's a monetary award. Going backwards and addressing one of the judge's questions, who has the burden of proof? Not the plaintiff, but I believe that the person requesting a monetary award has the burden to prove the three-step process and then argue under the factors that it would be fair and equitable to get a monetary award. My client, if you look at the facts of this case, is not asking for a monetary award. They'd agreed on some of their pensions were split. He got hers, she got his. But in terms of is she asking for part of his retirement? I mean, part of his businesses, or no, she wasn't. He was asking for part of her retirement because her retirement was a bit bigger than his. He had the burden to prove to the court that it would be equitable to get a monetary award. And in her opinion, she says, based on everything and based on how I value everything, I'm not going to grant a monetary award. Focusing on the issue first, whether or not the businesses were marital property. I point out to the court that those businesses were acquired during the marriage. So the statute says that something is marital property unless it is proven.
Can I stop you for a second? We get that, but
Okay.
But if he didn't get it by gift, how did he get it? There are a limited number of possibilities.
Good
Did he
question.
buy it? Did he buy it? Is there any evidence that he bought it?
There is no evidence that he actually purchased it. There is evidence.
So how else did he get it? Did he steal it?
It was compensation, like we say in our brief. He worked for that company, Your Honor, the entirety of the marriage. He says he worked 40, 50, 60 hours a week for that company. He basically ran it. He was on call full time. He would go up to, I think it was Ohio, where it was based out of, and work there once a month or something like that. He would run the books. He would take care of everything for his family. He made $15 an hour from that company doing this. His tax returns show that he lost several $1,000s every year. That's what his tax returns show, which none of that, I'm not saying the tax returns are illegal in and of themselves, but he worked and he made money from that. So the inference, which I think is reasonable.
Are you talking about the tax returns of the business or his personal tax returns?
Business.
Okay.
His personal returns, he contributed very little. My client was the majority wage earner. But he was able to work and build these businesses, essentially, have them appreciate during the marriage.
Let me put it this way. Aren't there like a million cases that say that when you are trying to determine the fair market value of someone's interest in a business, you need to have expert testimony?
I don't know that there's a million cases that say that.
Okay, aren't there like, 3 or 4 at least? I mean,
At least.
I don't.
And doesn't it just follow from the nature of the rules of evidence? I mean, who knows what the fair market value of his fractional share in this closely held business is?
But the judge was able to determine, Your Honor. So
Based on what? Based on what?
Well, the credibility of the witnesses. So,
but that doesn't get you $1 million or whatever number she came up with. What's the rational basis for concluding that there's some kind of willing buyer who's going to pay whatever number hundreds of thousands, whatever it was, for his fractional share, his minority share in a business where he can be fired and then he can't stop it. He has no right to a dividend. He's got no right to control management, and he can't sell it to anybody. What is the rational basis for the conclusion that she reached in this case as to the valuation of these businesses?
Mr. Camper testified. He didn't testify that the value was zero. He testified on his joint statement that it was unknown. So it was clear to the court that his strategy essentially was, I'm not going to get an expert. I'm not going to put on any value to it. And if I don't put on any value to it, this is a business that's in Ohio. These are not rich people. She's not going to know the value, and the court's not going to be able to do anything. Ha ha. That's not the way it worked out. The testimony from my client, who was credible, she worked at the business for several years while they were married.
What?
She talked to him.
What is she a business appraiser? Is she when I know you do this. I used to do it. There are a bunch of people in the business who do it, and they have credentials. What credentials does she have to value a minority share in a closely held business that sells antique clocks or something?
just the tax returns, which showed the gross income on. the
Okay, well,
several years. The
gross, so
con-
what about, but gross, that's like, maybe half of the equation.
Conversations with her husband over the years as to the values and just the general running of the business. She's been in the family for many years, working at the company for many years, knowing the values of the inventory, which was on the tax returns, I believe.
How about the basis in the end? Does she know what the basis is? For all we know, the inventory is underwater.
Well, I understand that, but that's well,
Okay.
the inventory isn't necessarily, the inventory is the inventory. In other words, there was
Okay,
no
but
indication that they
maybe-
owed money on it.
But how do we know they didn't pay more money, that the clock market has now declined and they didn't pay more money for what they have in inventory than the value of the inventory?
That would have been Mr. Camper's job to prove that, and he didn't do that. So he left the court with a situation where she had a joint statement of marital property. Husband says, I have no idea. I mean, even the joint statement of marital property says husbands own 15%, husband owns 25%. He wouldn't even testify that in his testimony. As another example, which not this one, when he put on his joint statement of marital property, first of all, it's T by E property, and he insists on putting it in category 3. It's T by E property. It had to be all marital property. He said the value of the property when he signed his joint statement of marital property, I think, was 193. And then in the middle of trial, when it seemed like it was the right thing for him to do, he said, you know what, I stipulate that it's worth 319. In other words, the judge didn't take anything he said seriously for good reason. And the judge did take what my client said seriously for good reason. And when my client said,
but some of the things that she credits, I mean, to take it seriously, there has to be a rational, factual basis for it. And I'm trying to understand what the rational, factual basis is for to conclude that a professional musician is capable of valuing a fractional interest in a privately held company that engages in this, it looks like a pretty esoteric market.
let's do it this way. Even if the property, I guess it's, well, if it's determined, I guess, that the only rational explanation is a gift and we don't have a value to it, then it's non-marital property. The judge still takes into
there actually is a value, at least as of the time of the gift, on the gift tax returns.
Right.
And it looks like it's a lot less than, I mean, maybe it appreciated in 13 years. I don't know. I'm not sure what the evidence of that is, but the number on the gift tax returns is pretty small.
Even if it is considered to be, even if she didn't meet her burden, I guess, although I think the burden is on him to prove that it's not marital property because she raised the issue and he simply said gift without not too much to support it. But even if you believe it's a gift and it's non-marital property, the court is still considering, and she speaks all over the place in the order when she's considering all the factors as she's required to do and as she does. She considers cause of the breakup. She considers financial resources of the parties, which is he has this business, regardless of what it's worth. He has a business that grosses hundreds of thousands of dollars a year. He is a shareholder of those businesses. It's family owned. There's resources. His mother gives him money. The testimony said the mother gives him money. She lent him $150,000 at one point. He didn't pay any of it back because he doesn't have to pay any of it back. He just said it was a loan. And all those things taken into consideration, the court, when refusing to grant a monetary award, even if it was non-marital property, the court determined that it would not be appropriate to grant him a monetary award out of her additional pension, because then if you calculate the numbers, she has a little bit more than him. But the court recognizes that, and I believe it's harmless error, and that even if the court said, you know what, it's not marital property, then I'm still not going to grant a monetary award. And that's all supported by the factors and her explanation of the factors and the evidence and the testimony of all 10 factors of monetary award. And that all makes sense because even if it is non-marital property, it's still his. She doesn't have it. And as I argued, at the time of trial, Your Honors, she was unemployed because there was a strike with BSO, and all she had was her retirement plan. He's working. He has these businesses that he's partial owner in. They could be worth $10 million. They could be worth zero. I get it. The court made a determination as to how much she thinks it's worth, but who knows what they're worth, but he has them. and they have income, and he makes money from them, and he has all these other assets. He has substantial retirement as well. He has a house that's worth more than her house. So in the final analysis, the court determines whether marital or non-marital, I'm not granting him money from her, granted attorney's fees because she caused the breakup because there was an affair. But in terms of equities, in terms of going forward, the court would not have granted her a monetary award, him a monetary award under any circumstances. So I understand what you're saying, and I do still think that the court has discretion to, and there's no requirement here for expert testimony because my client worked at the business, knew about the business, came across as a very intelligent person, was believable, and testified to this. So yeah, I know it's a round number of $1 million. The court said, yeah, that's what it, you know, if you're not going to tell me anything, Mr. Camper, as to how much it's worth, if you're going to refuse and play dumb, because obviously he knows more, he should know something if he works there every day, but he played dumb. Well, then I'm going to go with Ms. Camper.
I'm not quite sure. I mean, I've done cases involving business valuation, and I'm not sure how you would go value a business like this one. So, and I was a lawyer who did it, so I'm not sure that that Mr. Camper necessarily knows how to go value his business. And
He would hire an expert and value his business. I understand that.
Does this business have value if Mr. Camper is not employed by it?
Well, he is employed by it, but
Well,
imagine, of course it does. I mean, it has the inventory and it's been in business since 1986 or 1957 or something like that. And it has a substantial, you know, income every year.
What I'm saying is a lot of times these, you know, small, closely held businesses are dependent upon the participation of the owners, you know, because they have, you know, I don't know who the customers are, and I don't know how they acquire their inventory, but I'm guessing that he's got some kind of expertise in this. And if you were to value this business, you'd probably need to account for the extent to which the goodwill of the business is attributable to his continued participation. Right?
I understand what you're saying, yes. With regard to the other issues, again, the court had absolute discretion with regard to the personal property and the clocks and the vehicles to, you know, average the values of what one party puts on a joint statement, the other party puts on a joint statement. Mr. Camper said, I don't know what anything's worth. My client explained why. And for example, one of the vehicles, he had put for insurance purposes that the vehicle was worth $57,000. Yet on his joint statement of marital property, he said it was less than 20. My client said, well, it's worth $57,000. The court said, I don't know if either one of you are exactly right, but I'm going to average the two, and I'm going to make that as my determination. And I think she had the absolute discretion to do that. And that follows with all of those other personal property. One of the values, he said it was a gift, and she said no. We bought that together during the marriage. This is where we were. We went, we used our funds, and we bought it. And he didn't respond to that because, again, the testimony was that he was simply saying what he needed to say to try to, you know, get the best out of it in terms of monetary award, trying not to give any information. And my client was very credible. So that's why the court came down in her favor. But ultimately, like I said, whether or not that business is a gift or whether or not it's worth $10 million or $0, the court's inclination was not to give him a monetary award. And she explained that well, regardless of what the value of the business was. And I think that is harmless error, essentially, and should not be remanded. And everything else, I think, is by the book in terms of what the court said. She was very upfront when she said it. You haven't given me enough information so that I believe either one of you. So what I'm going to do in my discretion is average them. And that's what the court can do. And that's what, you know, the court should do. I mean, sometimes you don't want to get an appraisal or pay for an appraisal that might cost more than the property itself. That happens a lot, and it's up to the court. And if the parties don't agree, you know, I think the personal property in the house is worth $2,000 and I think it's worth $5,000. Nobody gets an appraisal. The court makes a determination, and that's okay. And that's what they do in family law cases under the monetary award statute. That's all I have. Thank you.
Thank you very much, Mr. Moran. You have a little bit more than 4 minutes left.
If it please the court, I've enjoyed the conversation being with you all today. I have no rebuttal.
Okay, thank you very much.